Good afternoon, everyone. I see it's 12:30, so we'll go ahead and get started. My name is Jessi Thaller-Moran. I'm a labor and employment attorney in the Raleigh office for Brooks Pierce. I'm here with my colleague, Natalie Sanders. We appreciate you joining us today for our presentation titled Get the Workplace in Shape for 2022, which is a little bit of a cheesy New Year's pun, but really focusing on some of the trends that we anticipate will be relevant in your lives as employers over the coming year. A couple of housekeeping items. If you have a question you'd like to submit during the presentation, please use the chat function and that will come to Natalie and myself. We will have a SHRM code that is available at the very end of the presentation. And tomorrow we will send a copy of the recording from today and a copy of the slides, as well as a link to some of our other presentations and news alerts that might tie into some of the topics we touch on today. So as I mentioned, I'm Jessi Thaller-Moran. I'll let my colleague Natalie introduce herself briefly if she'd like to do that.
Hi, I'm Natalie Sanders, and I'm happy to be with you all today. I'm filling in for Elizabeth Troutman, who had something come up and she was unable to be here. But looking forward to projecting a little bit about 2022 with all of you.
And projecting is a good word, right? We don't have a crystal ball, so a lot of this is our speculation as people who follow a lot of these developments and news alerts. So hopefully we can give you some good information. And in that vein, and if you have attended our prior webinars, you've seen this disclaimer in the past, please just remember this is general information, crystal ball gazing, if you will. This is not individual legal advice. And if you need counsel in that vein, we would recommend you contact legal counsel, and we'd be happy to be those attorneys for you if that would be helpful. So I will spare you all the cheesy voice, but we are here to pump you up about enforcement trends in the new year. So we've narrowed the topics for today down to 10 different trends that we anticipate. I'm going to touch first on what we believe is going to be one of the overarching omnipresent trends of the new year, which is retaliation. And when we talk about retaliation, it's in this very broad sense that it is unlawful for an employer to retaliate against an employee for engaging in protected workplace activity. And both of those terms, retaliate and protected workplace activity, are kind of intentionally broad under the law, a little bit amorphous. So when you're thinking about protected workplace activity, you should be thinking about seeking an accommodation for medical or religious reasons. Complaining about working conditions might be protected activity. Discussing rates of pay or vacation days or schedules with coworkers. Filing a charge or a complaint about harassment or something related to the workplace, or participating in an investigation with regard to a charge or complaint. So again, very, very broad. And looking at 2022 in particular, be aware of this in the context of someone complaining about vaccines or masking or scheduling issues. We expect to see a lot of medical leave or medical or religious accommodations this year, which we will touch on more in a minute. Social media activity, to the extent you have employees who are out on their social media accounts saying things about their working conditions, that might be protected. And conferring with union reps as well. We are expecting to see this trend towards unionization continuing. So the takeaway here as we look at protected workplace activity is that when in doubt, think twice, consult counsel before you respond to someone engaging in workplace conduct that feels detrimental to you as an employer. And what is retaliation? Well, that also is broad. The EEOC says it means that the employee is punished or treated differently or harassed. And I can tell you that what we're seeing in the enforcement side of things is that this can range from passing someone over for a promotion to demoting somebody to even a sense of isolation at the workplace, right? As in, I used to get invited to this lunch and I'm not invited anymore. So again, very, very broad. The powers that be, the agencies and the courts, are looking for conduct that would arguably discourage an employee from engaging in that protected activity. So as an employer, you want to watch for timing or circumstances that might give the appearance of retaliation, even if there's a legitimate business justification. So when you are planning to demote somebody, transfer somebody, shift them to a different schedule, or conversely, if you're planning to give a group of employees a pay raise and a bonus and someone is excluded, it's good to double check and make sure that the person who is negatively affected has not recently engaged in something that might be considered protected activity. And with that, I'm going to turn it to Natalie for our second trend.
Great. So our second big trend is OSHA and workplace safety. And as employers, you have gotten your fill of that over the last 2 years. It's not going to go away. I thought what I would do is first give you a brief status update on where some of these issues are, because there's been a lot of press, a lot of reactions to the Supreme Court decisions, and a lot of questions about what does all this mean. So just a real quick update on where we are. So if you are in the healthcare industry and covered by OSHA's healthcare ETS, that expired back in December. However, you need to keep in mind that some states are state plan OSHA's plans, meaning that they run their own rules and they just have to be at least as severe, at least as protective as the federal OSHA guidance. And so many of these states implemented this ETS, including North Carolina. And so they're not required to withdraw it. And in fact, if you go on the North Carolina site, you will see a clear statement that this is still in effect in North Carolina, and it will be in place at least through February 28th, and that it was adopted as a permanent rule in North Carolina, not as an emergency temporary standard. So whatever state you're in, if you're in the healthcare industry, you need to be looking to see, you may still be under that. The other one, the OSHA 100 ETS is kind of what we shorthand call it, that said employers with more than 100 employees were going to have to do several things, including institute a mandatory vaccination policy or have unvaccinated workers test weekly and wear masks. So we know that this had all sorts of legal challenges. The last legal challenge was at the Supreme Court, and it was challenging whether or not there would be a potential immediate harm to employers if they had to do this, and if it was going to be something that they had to keep from happening immediately. And so the Supreme Court issued a stay, meaning OSHA could not implement and enforce it. But it didn't go away. It was going back to the lower courts. Well, OSHA then announced they would withdraw the emergency temporary standard, and they did that effective today, actually. So the emergency temporary standard for those with 100 or more employees is not out there. However, it is gone but not forgotten. OSHA has clearly stated that they view that rule also as a proposed permanent rule, which means it will go through OSHA's normal process for rulemaking. And when they originally issued it, they said that as well, which means we are already at step, I believe, 4 in their 6-step process to making it a permanent rule. So we are through the public comment period, and now they have to digest all of those public comments and consider what they've heard from the Supreme Court before issuing a potentially new final rule. So right now, that's in limbo, but nothing that you have to do except this. If you have already issued that rule, are you going to continue with it or not? Look at the various state laws that may come into play, because there are some states saying you can't have mandatory vaccinations. Also, think about the PR situation you have. You've probably seen Starbucks withdrew their vaccine or test mandate, and they've gotten a lot of hashtag boycott Starbucks going on. So there can be a lot of reactions one way or the other on that. So that's where we are on those rules. North Carolina, again, I said it was a state plan state, had not implemented that OSHA 100 yet. And they have notified that they're not going to unless and until there's permanent rule situation. So that's the status on those two major OSHA rules. Now, it's still going to continue to be a hot button topic because the thing that never goes away is the OSHA general duty clause. And that requires all employers to provide a safe workplace, free from hazards. And we're learning more and more about this. So what do? Well, you know that OSHA is certainly going to consider, if you followed that ETS, to be something that would meet the general duty clause standard. So there's still some consideration of whether you want to go through with that. Otherwise, look at the OSHA website, and they have something that's general for all employers called Mitigating and Preventing the Spread of COVID-19 in the Workplace. It's a guidance, it's not a rule, but it gives you a lot of things to think about how you meet this general duty standard. And then record keeping. OSHA does have rules about when you need to record COVID cases that you can associate with being originating in the workplace. And certainly then if that leads to a death or hospitalization, you have OSHA reporting obligations. So that's kind of our OSHA status. One other thing I want to bring up in the OSHA context, though, that applies to all 10 of the trends that Jessi and I are going to talk about today. And that is the big issue of remote work. We didn't set it out as a separate trend because we think it falls into so many of the other trends that we've identified. And so we're going to try to mention it in the different contexts and what the real remote work issues are in these contexts. And then we would also encourage you to look at some of our prior webinars where we went a little deeper into some of those remote work issues. But in the OSHA context, the question is, if I have people working from home, what are my OSHA obligations? And OSHA has, as a general matter, said we're not going to police the home office, but you still have your reporting obligations if there is a workplace injury that happens at home. Keep in mind, your obligation is to provide a safe workplace, not a safe home for employees. So of course, the employee must be working and it must be something that happened while they're in the course of that work and getting paid. So if I have a home office and I'm sitting in my home office chair and I fall out of it while I'm working and I get hurt, that could be an OSHA issue. Also need to be thinking about workers' comp, all of those sorts of things. So the remote work situation and OSHA, those things are going to tie together. And if you have people who are not in an office work from home situation, but are at home and they're doing other types of work, you may have some higher obligations on how you maintain that safe work environment. That's a lot on OSHA and workplace safety. Jessi, I'll send it back to you for the next big trend.
And I will chime in before we switch slides just to say, remember OSHA existed before COVID. And a lot of what OSHA does, we have spent a lot of time talking about OSHA enforcement in the COVID context today and over the past 2 years. But there are general workplace safety concerns that OSHA also investigates and provides guidance on. And so if you as an employer have not spent time looking on the North Carolina OSHA website in a while, it might be a good idea just to see what's out there and what guidance might apply to you as an employer, COVID and remote work concerns aside. So with that, I'll go to our third trend, which we've kind of grouped together as Title VII enforcement. So Title VII, if you are not familiar with the law in particular, is the federal law that prohibits discriminatory employment practices. So race, color, national origin, sex, which we now know includes pregnancy, sexual orientation, gender identity, and religion. We've seen some communication from this administration that they intend to ramp up the enforcement with regard to Title VII, and we're seeing some parallel language from the federal agencies, which I'll talk about in a minute. So again, going back to the retaliation discussion in the beginning and also the remote work issues that Natalie just raised, be cognizant anytime you are making certain conditions available to some employees and not others, that you are not disproportionately benefiting or harming one group over another. It's always a good idea to check in periodically with regard to demographics. And in the remote work context, for example, how are you deciding who gets to work from home? Are there presumptions about availability being made about women who are working from home with children versus men who are working from home with children? I think we're going to continue to see all of these issues kind of meld together as the workplace shifts to whatever it will become 2 years into this pandemic. In terms of Title VII in particular, I think we're going to see more public outreach and education efforts. So, educating employees on what their legal rights are. I think I'll talk about this more in a minute. We'll see more frequent and thorough government investigations. So something that in the past might have been kind of an open and shut, an EEOC charge is filed and the employer responds and then the agency closes the book and says there's nothing here. I think we might see more interest in poking around a little bit more and just in general, more federal agency activity. And in that vein, I wanted to talk a little bit about what we're seeing from the federal agencies as a group. So there are different agencies that enforce different laws, right? The Department of Labor is looking at generally wage and hour issues. The National Labor Relations Board is looking at workplace concerted activity, unionizing and collaborating to improve working conditions. And the EEOC is charged with enforcing Title VII anti-discrimination. This is a very simplified description of what these agencies do. But in theory, they each have their own range of laws they are enforcing. What we are seeing, even in the past 6 weeks, is that there is an intention for the agencies to share information, to work more collaboratively with regard to some issues that they perceive to be overlapping. So in November 3, the Department of Labor, NLRB, and EEOC announced a joint initiative to raise awareness about retaliation. They held a webinar in which they discussed retaliation in the workplace and the perception on the agency end that this is kind of a rampant issue in the workplace that they feel touches on a lot of issues and often goes not addressed. So I think we'll see more enforcement activity from each of those agencies individually on the retaliation side and then also together. Similarly, in December, we saw a memorandum of understanding between the NLRB and the Department of Labor about concerted investigation efforts. So sharing information that, let's say there's one investigation ongoing by one agency and they uncover something that falls in the gamut of another, they might kind of tag out and say, hey, here's something we think you might want to look at. Coordinating investigations as a result, or even just enforcement activities in general. And I think we're also going to see some more outreach from those two agencies as a concerted effort as well. And so if you're an employer and you are kind of staring into 2022 and whether or not you've had experience with an agency investigation in the past, I think the big takeaways to have here are that we're going to see more investigations. They're going to be more expansive when they occur. And so it's a really good idea, again, to kind of get your personnel files in order in anticipation of not if, but when you get a notification that there's an investigation or a pending charge. When you have charges filed, I think expect that you might start with an unfair labor practice charge and end up with a wage and hour charge because of what we're seeing about the intention to share information among agencies. And we're also seeing some communication from the agency heads about seeking a broader range of damages, either in settlement or in a proceeding if it goes forward. So you might see, whereas in the past it might have just been a settlement that involves lost wages, maybe now you have lost wages and emotional distress payment that the agency is seeking on top of that. So they're really signaling, again, even in the last 6 or 8 weeks, that they are coming as a unified force more than we've probably seen in the last few years, and that they are intending to root out unfair labor or employment practices. And I am going to pass it over to Natalie for what's going to be one of our bigger topics. I feel like we're saying that for each topic though, so maybe they're all big and important.
They are, and that's why we've picked them as the trends that we wanted to highlight. I want to talk to you a little bit about medical leave. And the reason we have said we think this is going to be a big trend. Again, has a lot to do with the last 2 years and what we've been seeing. So we have a group of people who've been through COVID, and you've heard of long haul COVID, and you've heard of a lot of complications from COVID. So we expect there to be more requests for accommodations relating to the medical issues associated there. The other thing you've seen in the news is the psychological impact, the impact that all of this has had on mental health. And so we think you're also going to be seeing the trend for accommodation requests relating to mental health issues. So it's both physical and mental. And it's going to be a little harder to differentiate where that line is, I think, as we're coming into 2022. So all of that in mind, we're looking at the Americans with Disabilities Act, saying you need to accommodate those with disabilities. We're looking at the Family and Medical Leave Act, saying that you need to provide people with a certain amount of job protected leave if certain requirements are met. And then local laws. There are a lot of states that have similar laws. And so you need to be aware of those because they can have different standards. In North Carolina, we don't have what we call a mini FMLA. So you don't have that. We do have a law that protects against discrimination based on disabilities, but it hasn't really gone to the level of having any accommodation associated with it, especially not that's different than what you would see under the Americans with Disabilities Act. So we're not going to talk about anything separate North Carolina related there. Go ahead and go to the next slide, please, Jessi. So FMLA first, because that's typically where it starts when someone needs a leave. If they have worked for an employer for at least 12 months, 1,250 hours in the last 12 months, and at a work site that has 50 employees within a 75-mile radius, they're going to be eligible for FMLA. So smaller employers or employers that don't have big work sites may not be applicable to you. But I want to raise, again, remote work issues here, because under the FMLA, if you have people working remotely, their home office or their remote work location isn't a separate work site under this statute. Instead, the way this works is, where are they reporting to? So you can't escape FMLA by simply saying you're going to let everybody work from home. So if everybody's reporting to the same corporate office, then all of those employees count as being within that 75-mile radius. So keep that in mind when you are thinking through whether or not your employees are eligible for this type of leave. And then what reasons can you be responsible for granting this leave? Serious health condition of the employee, the serious health condition of someone they're responsible for, like their spouse, their child, parent. It's also available for new children being placed in their home through birth, adoption, or foster care. And then there's also the military aspect of this leave, which is for someone who is covered and you have a family member. It's going to come into play here as well. But where we see the trends, we think it's going to be more having to do with the serious health conditions. So next slide. All right. So in addition to the Family and Medical Leave Act, we have the ADA, which is you're qualified to do your job, you have a disability, and it's impairing or limiting you in some way and affecting your job. So you're otherwise qualified for the job, but something is making it not quite right for you to be able to fully perform that job. In that case, then you need to go through a reasonable accommodation process, and it must be interactive. Of course, the accommodation that's requested must be reasonable, and it must make them able to do their job. But the key here really has to do with this interactive process. You want to engage with the employee and you want to keep records of that. And I'll talk about that on the next slide a little deeper, but before I move, I want to just point out this physical or mental impairment that substantially limits a major life activity or a record of such impairment. Because this goes back to the COVID situation we mentioned and that we thought we would see more of these. Think about the things you're hearing about people who've had COVID. Ongoing breathing issues. Mental fog is one we've heard a lot of. Effects on their taste, smell. Those are all going to be major life activities that are going to get them qualified under the ADA. All right, next slide, please. So this is an important one. There are a lot of examples up here, but I think the key here is there are no magic words. An employee who is connecting their health to their ability to perform their job, whether that means showing up on time or showing up at all, that's enough to trigger these laws. It's enough to give someone notice. So if you take nothing else away from this, take the time to train your supervisors and managers that if an employee in any way ties some sort of health condition, physical, mental, emotional, to their ability to do their work or show up for their work, that's enough for them to know they need to get HR help, okay? And all of these examples are enough to really trigger that you need to think about this. So if an employee is asking for a change in their working conditions, maybe they filed a workers' comp claim, or maybe it's obvious that they're not doing their work well and they need help in some way, and it's due to a medical condition. Or look for trends. They don't say anything, but they call in late for work on a regular basis saying, I've got a headache. That could be enough to trigger a conversation to say, all right, let's talk about what's going on here, because they've connected their not being able to come to work to some sort of health condition. So if you have a separate HR group, I really say, talk to your supervisors and managers, give them the tools to find that red flag, and then turn it over to you so you can get that consistency in carrying out this accommodation process and document it. Next slide, please, Jessi. So these two things tie together. As I mentioned, a lot of times FMLA starts it, and then you kind of get to the end of the FMLA and they need more leave. And that then carries you over into the ADA, or they're going on concurrently. Keep in mind that these things can be a set length of time and the person's back, could be intermittent. It could be an ongoing accommodation. So there are a lot of things at play here. The other thing to remember, and Jessi talked about this with respect to retaliation, but there's also under the FMLA something a little different than retaliation, which is interference. It can be a violation of the Family and Medical Leave Act to interfere with their exercise of those rights. So what does that mean? It could be terminating somebody before they ask for that leave. It could be dissuading people from asking for the leave. So be aware that you really need to have in place good policies on these things. It's clear how they ask for the leave. It's clear how you're going to decide, make the decisions and communicate with them, and then the supervisor training. Finally, I want to mention the record keeping. Again, the key is that interactive process. If you can show that in good faith, you have been interacting with the employee, that is the biggest thing, to show you're engaging in those efforts required by law to find a way to help them do their job. Document that. And then I also think if you don't have forms prepared, ready at hand for carrying out the FMLA, which those are readily available on the Department of Labor website, or your accommodation forms, or at least some checklists, those kinds of things, you need to get those in place. And then I'm finally just going to mention that the accommodation process under the ADA that may include leave. Keep in mind that there are also accommodation obligations under Title VII for religious reasons, and you've been seeing those come up in COVID as well. So have forms ready for those as well. All right, back to you, Jessi.
I was just going to say, as you were talking, one of my favorite go-tos in a situation where an employer has their spidey sense kind of tingling about a medical issue is to ask an open-ended question like, how can I help you? Because it can be so treacherous to make assumptions about, oh, you have a headache, you must have a medical condition, let's talk about it. You don't want to, it's such a tightrope walk. And I think the more you can put the ball in the employee's court when you're initiating that interactive process to say, hey, what would be helpful to you? And let them disclose what they're looking for and why. I think that can go a long way in having a productive, accommodating discussion.
Absolutely.
All right, well, when I made this slide, I was like, oh, everyone's tired of hearing the word COVID, so we won't talk about it, except I think Natalie and I have already used the word COVID probably 50 times in this presentation. So please just enjoy the gratuitous Harry Potter reference and I will move on. The next trends that I'm going to talk about are COVID specific. I guess everything in some way is these days. But talking about workplace accommodations that are specific to COVID, because we are still seeing some of these things that first emerged in summer 2020 continuing to be an issue. The first being accommodating someone who has health and safety concerns about being in a working circumstance because of COVID. First, I'll flag, like I did in the first slide, that if someone is expressing concerns about appropriate masking or distancing or hand washing or anything like that, they are very likely engaging in protected activity. So even if your first inclination is that this person is a squeaky wheel, it's probably a good idea to hear them out. I've added the language about the ADA accommodations again, just for consistency. When someone comes to you with a request for an accommodation and it's not clear what the medical issue is, or you feel you need some more documentation, you're allowed to do that under the law, but it is limited and constrained in how you can request it and what you can request. So you can request information that is job related and consistent with business necessity. You cannot demand that the employee turn over like their entire medical record so that you can see the history of when they were treated for migraines. On the same token, don't go overboard on behalf of someone that you perceive to be high risk and presume that they need or want accommodations. So if you have employees who are of a certain age or pregnant, or that have a pre-existing medical condition, it's inadvisable to go to them and say, well, I've decided for you that you won't be eligible for coming to this work meeting because I want to keep you safe. That's going too far in the other direction. So that's something certainly to think about as well. And then the other thing that I know people are hearing very frequently right now is concerns, maybe not for themselves in particular, but maybe for a high-risk family member, or maybe they have young kids, or maybe they just in general feel unsafe in COVID times. And that family members and things like that do not qualify them for ADA protections. Still probably a good idea to hear them out. But if they have a general health or safety concern, you might even have to get into that interactive process just to figure out what the concern is and get it more clearly articulated, what the need or concern is and what they are seeking as an accommodation. I'll just say again, speaking in the vein of mental health, I think people are on eggshells enough right now that the more accommodating conversations, probably the better. The second kind of accommodation we're talking about a lot these days, obviously, is accommodations from vaccines and masking. We are seeing municipalities and states pop up with variations of prohibitions on these. And so if you are not staying up to date on these, and if you have employees in several jurisdictions, I would highly recommend connecting with legal counsel, because it really is, it's like whack-a-mole. you think you figured out the law, and then the law in one state evolves a little bit and it changes what your policy can be and how it can be applied. So that's step one, to the extent you have workplace policies that maybe align with OSHA but could conflict with a more local law. To the extent you have a vaccine or masking requirement and someone is seeking an accommodation for medical reasons, again, just like on the prior slide, it has to be job related and consistent with business necessity for you to seek more medical information. And you're looking for whether the accommodation they are seeking is reasonable. And we have some guidance from the EEOC in this vein that I will flip to in a second. Similar analysis for accommodations under Title VII. The catchphrase here is sincerely held religious beliefs. And in general, the expectation is that an employer takes an employee's religious beliefs at face value unless you have an objective basis for questioning that. And the EEOC cautions in its most recent guidance that just because you had a sense of what someone's religious beliefs were a few years ago, beliefs can change, they can grow stronger, or they can dissipate. So this is a place, again, where you really need to engage with the employee and figure out what they are seeking and the basis for doing that. To the extent you have a vaccination policy in place, we've seen a lot of employers including kind of an open-ended form for employees to complete if they believe they need an accommodation. So we're seeing a lot of dialogue in this space. And as Natalie mentioned, with the anticipated OSHA rule, I don't think that's going away. And here's I think one of the most interesting pieces of the EEOC's guidance in this area, which is to consider all options before denying an accommodation request. So this is always the standard, but especially when you're dealing with COVID-related accommodations, vaccine exemptions, that kind of thing, really brainstorm what can you reasonably do as an employer to accommodate this medical issue or these religious beliefs. Things that the EEOC suggests you consider are the proportion of employees in the workplace who are already vaccinated, the extent of employee contact with people who don't work for the company, right? Are they in a medical facility where they're dealing with a vulnerable population? Are they working at a Starbucks and handing out coffee to members of the public? Are they in an office where they're relatively isolated once they sit down at their desk? Those are all going to factor into the accommodation analysis. And that's another reason it needs to be such an individualized analysis for each employee who comes forward with a concern. And then lastly, this quote ends by saying that when in doubt, rely on CDC recommendations. So we know that that's very much a moving target, but as we get more guidance from the CDC, from OSHA about what constitutes a safe workplace, that will in turn inform our analysis for reasonable accommodations.
All right, so I'm going to talk about the personnel files. Jessi mentioned personnel files early on when she was talking about making sure that you're prepared for these extra investigative and complaint response things coming out of the federal government, especially, and the coordination among the different agencies. And so you're going to see more inspection of your records. Be prepared. This is the time to go through and review what your record management policy is with respect to your employee files. And here are some things that you need to think about. Number one, the Americans with Disabilities Act requires that you keep medical information that you've collected separate and apart from personnel files. So if you aren't keeping that information separated, you need to, and you need to go separate it now and create those separate files. This again ties in with things like, are you getting proof of vaccination from your employees? Those proofs of vaccination are going to contain medical information that can't go in the personnel file. So you need to think through how you're maintaining all of these records. It gets complicated too if how you're maintaining them is electronic versus paper. It used to be all paper and it was easy to say, have a separate file cabinet with a lock key for the medical information. Well, now we live in an electronic world. So what does that look like? Oftentimes it means that there's very limited access and passwords and all of those kinds of things to get to certain information. Then the other thing I want to flag is how many different files should you have? So we think about a personnel file and we think about a medical file often when we're talking about HR files. The other one we often think about is the I-9 file. So you're routinely being told, keep your I-9 separate from your personnel files, because if you get that investigation there, you want to be able to just show the I-9 forms, right? And now we're talking about all these other agencies that are saying they're going to coordinate. And if they see something in the course of their investigation, they're going to be flagging it for another agency. So how can we respond to that and prepare? I know it's work, but think again about how you might divide your personnel files. I think there has already been a trend to separate payroll related documentation from the personnel file. That's a very good practice because if you get that wage and hour investigation, you're going to have all of the pay information separate from the personnel file, right? Investigations. If someone does complain about something, does express a concern, then a file about that concern and that incident, separate and apart from your personnel file, is going to end up being a best practice. That's a lot of different files that we're talking about, but it makes sense, especially with the trends that we're seeing. So what you should do is, number one, go through the current personnel files, kind of do an audit. What do you have in there? Do you have medical information in there? Remember, we've been talking about remote work. So when you get those requests to work remotely, is that a medical accommodation request? If it is, all that information related to that medical piece of it should be over in your medical, right? If it's just someone that you're having a remote work policy now, a lot of employers are going to a 3-2 model or a 2-3 model of how often you have to be in the workplace. Some are going individualized arrangements. You need to document what someone's arrangement is and get that in the personnel file. But getting it into the right place is going to be very important. And this ties together with the next trend, which is workplace discipline. Because when you have people working remotely, having a remote work policy, or at a minimum, getting good documentation of what the arrangement is with that particular person is going to be very important. Because how do you give feedback? How do you set the expectations and set a person up for workplace discipline when appropriate? I mean, obviously what you want to do is coach and improve and set people up for success, but at some point you need to also be thinking in terms of, does the feedback match what eventually will become a performance evaluation? Workplace discipline should never come as a surprise, nor should a termination. So how are you documenting all of that? So a couple quick thoughts there. Number one, you've really got to start avoiding words like, or terms or phrases, you're not a good fit for the position. You're not suited to this type of work. You're not projecting the correct attitude or image. This just isn't working out. All of those types of phrases are no longer going to cut it if someone's saying, you've retaliated against me, you're discriminating against me. All of those wishy-washy wordings that we think we're being polite and nice, they won't create a defense for the employer, and they won't give a good message to the employee. When it doesn't feel good, when it doesn't feel fair, that's when you get sued. So the best advice we can give is direct feedback and timely feedback. Don't wait for the straw that breaks the employer's back. You need to go ahead and be giving clear responses along the way. We all by nature or most of us want to avoid conflict. And so we don't give good feedback. So as you're looking at what is 2022 going to look like for you and you're planning training, think about incorporating some training on feedback, both giving and receiving. That can go a long way to making sure you're not going to have discrimination and retaliation claims because people are engaging in the right kind of feedback. Okay, I'm going to toss it back to Jessi.
All right, so I'm going to tackle our 10th and final trend that we anticipate this year, which is increased enforcement in the sex and gender discrimination area. You all probably remember the news from a few years back when the Supreme Court issued a ruling that said Title VII and similar anti-discrimination laws, when they say they protect against discrimination based on sex, that includes gender identity and sexual orientation. And just like in other areas of enforcement, we're seeing an indication from the administration that they want to ramp up enforcement in this area. And in fact, that any existing guidance not consistent with this ruling needed to be reworked. So what does that mean as an employer? To the extent you have equal employment opportunity policies in your handbook or on your website, make sure you are explicit about what kinds of discrimination you do not expect, or do not tolerate. Watch for things that might feel very, very standardized, but could be perceived as gender discrimination. Is your dress code written in a way so that men wear certain things and women wear other things? That could be a recipe for trouble. To the extent you are working with a workers' compensation carrier who encourages you to provide light duty accommodations for someone who has a workers' comp claim pending, make sure that opportunity is available for, say, someone who is pregnant, right? We've seen situations at the Supreme Court where employers got into trouble with that inconsistency, even though in their mind, they're very different situations. And then anytime you're making hiring decisions, promotion decisions, making opportunities available to certain employees and not others, take a moment to look at the demographics of the pool that's been selected and make sure it's representative of your overall workforce. And then with organization leadership itself. So your executives, your board of directors, if that's applicable, are you doing what you can as an employer to demonstrate that you are dedicated to providing a non-discriminatory workplace? So that is what we expect to see in 2022. I will move to final reminders in a moment, but I see we have a question. I'd love for Natalie to weigh in on this, which is what you are seeing in the landscape with regard to requiring vaccinations of new hires.
I actually have had employers who've been asking about that. Can we sort of grandfather all of our current employees and then only hire people who are vaccinated? And that's a very case-specific situation. You need to evaluate your circumstances and why you are doing that. And can you differentiate appropriately? If you determine it's the right policy for you, it can be done, but you really have a lot to think about. We're happy to talk through that with you. The thing you need to remember that you cannot do is forget to accommodate. So even if you decide that's going to be your policy, by law, you still have to give those same accommodation considerations with respect to disabilities and religious beliefs to new hires and applicants. So there's no way you're going to have a hard and fast 100% rule on this because of that. And then you need to think through, how does that play out in your workplace? So the answer is it can be done. Has to be done very carefully, very thoughtfully, and it does depend on the industry and the specific employer's situation.
Yeah, I feel like our answer to so many things ends up being, it depends, but I think this is another area where it does.
Yeah. Hey, Jessi, I have a question for you if we've got a little bit of time left. So on the last slide, you were talking about the trends regarding the sex discrimination and what that means and things. You know, as I recall, we've seen a case not that long ago where there was a reverse discrimination claim and a substantial award, where the man, I think a white male, basically was saying he was tossed out because the organization was trying to increase their diversity, I guess, at the top levels. And as a result, he was terminated. Yeah. So can you talk just a little bit about that balance and how employers can be promoting what they want to promote without ending up being this example case?
Well, and it's funny, as you're saying that, it's been a while since I read the news on that specific case, so I don't remember the specific reasoning in that outcome. But in general, I think this is another example of why it's so important to have clear policies and clear criteria for what you are looking for. Because the expectation for you as an employer is not that you are waiving requirements for employees, but that you are consistent with the metrics for what matter in terms of employee qualifications and performance. And so I think the more training you're providing supervisors about what to expect of their employees and how to provide that feedback, and the more you have a clear enumerated policy for how you conduct hiring and promotion and all of those things, the better off you will be in a scenario where something like that happens.
All right.
So I'll hit on a couple of final reminders that have been themes in what we've talked through today. Documentation, obviously, I feel like we've beaten really heavily today, making sure that your files are in order and that they're thorough, and that to the extent there need to be things noted in someone's file or in a policy, that they are done sooner than later, so that you don't catch yourself scrambling when an investigation comes knocking or if there's a lawsuit that arises. I think in that vein, you should expect to hear from agencies more than you have probably in the last 5 to 7 years. So don't be surprised when that happens. But do, ideally before they come knocking, reach out to legal counsel, because our goal is really to help you avoid as many problems as we can on the back end. And it's a lot easier for us to do that if you come to us at a moment of relative quiet to work through some issues. And we may spot things in your files that you don't realize are an issue. So easier for us to help you before the EEOC is conducting an investigation and calling up the Department of Labor to come help. And with that, I will switch over for any more questions. Give you guys a minute. I know we've been incredibly thorough, but I'm sure we left some things out. Well, Natalie and I are both available for questions. If you do have any, our email addresses are at the beginning of the presentation and you will receive those tomorrow. I appreciate you guys spending your lunch hour with us. Your time is very appreciated. And I'll let Natalie chime in before we switch over to the SHRM code.
No, we really appreciate all of you taking the time with us, and we hope it's informative. And again, you've got our emails, and also let us know if there are particular topics, because we plan to keep doing our webinars this year. So if there are particular topics of interest to you, email those to us. We'd love to hear from you.